The underlying principle of the Geneva Conventions is that while during the conduct of military operations it is permissible to target and to kill people who are engaged in combat on the other side, once those people are no longer active as combatants, then it is not permitted to target and attempt to injure or kill them. They must be protected according to the provisions laid down in the Convention. Similarly with civilians, the basic idea is that civilians, since they're not combatants, they're not participants in the armed conflict as such, are entitled to specific protections which recognise that status. There is a very detailed regime set out in the Geneva Conventions, in particular the third Geneva Conventions, the one dealing with prisoners of war. When Australia is engaged in military operations and either takes people captive or if people, combatants, surrender to it, the third Geneva Convention generally kicks in a situation of international armed conflict. There are slightly different rules which apply where it's a non-international armed conflict, but I think the conflicts we're talking about in Afghanistan and Iraq are international armed conflicts. What it triggers is that if someone falls into the power of Australia, this makes Australia into what's called the detaining power. And Australia's obligations are then to ensure the welfare of these persons who have been captured and to treat them in accordance with the provisions of the Convention. The first thing which they have to do is to consider whether they qualify for prisoner of war status. There are certain criteria laid down, including whether you're a member of an organised armed force belonging to a state, or whether you're an organised militia, and various criteria. But generally the way it works is that there's a presumption that people are entitled to prisoner of war status until basically there has been time to verify that or to find that they are not so entitled. So the underlying obligation is to treat them humanely, to look after them, to remove them from danger, and to remove them to a place where they may be detained, in which a series of detailed regulations kick in. So the basic obligations of humane treatment obviously are you can't mistreat them, you can't inflict psychological harm on them, you can't torture them. They're, I suppose, the high-level obligations, and there are a whole series of much more detailed obligations that apply to prisoners of war. Yeah, once Australia has taken persons captive and they're in its power and the obligations of the Third Geneva Convention have kicked in, Australia may transfer those captives to another country. However, it's restricted by Article 12 of the Third Geneva Convention. It may only transfer them to another country that's accepted the Convention. But of course, nearly all countries in the world, or all countries in the world have effectively accepted it. But it also has to satisfy itself that the other country is willing and able to carry out and to ensure the provisions of that convention are properly implemented. Now, once it has made that transfer, Australia's obligation does not end. It is not primarily responsible for the treatment of the captives, the detainees, but should it turn out that the persons, when they're transferred to the second country, are not being treated in accordance with the Convention, Australia is under a continuing obligation to seek to remedy that, so that the provisions, the protections of the Convention are observed, and if that is not possible, then to request that the detainees be returned to Australian custody, and the other country must observe that request, must accede to that request.